He has the paperwork. Oh, you're bringing it. Okay. What's my date? 28.
Here we see one of the most critical early moments in any felony case, the discussion over a forensic evaluation. That's not about fingerprints, it's about mental competency. The defense believes Joshua may not fully understand the proceedings, and that's a constitutional concern. But Joshua's confidence and self-representation claim? That's a red flag. Many defendants who reject counsel underestimate how complex court procedure really is. What do you think? Should the judge respect his right to represent himself or step in for his own protection?
Court does call the case, people versus Joshua Wara.
Trevor Mabel for the people here.
We are ready in this matter. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Wara. Mr. Wara, state your name for the record.
Joshua Wara.
All right.
He gets Lauren Brown. That's perfect. That's perfect.
And this is a date and time I had set preliminary examination in this matter. My understanding is you would like a forensic evaluation.
That is correct, Your Honor. Based on my conversations with Mr. Wara.
Forensic evaluation for what? What's going on here?
Based on my conversations with Mr. Wara, I believe that it is necessary.
Hey, I'm representing myself. What are my charges? What am I in here for? I'm representing myself. I don't need a barcode to represent myself. What am I in here for? What charge am I on here for? I don't need a forensic exam. I'm not mentally disabled. I have ADHD and PTSD. I'm perfectly fine. I'm not on Social Security.
Sir, you are before the court on a felony complaint that alleges that on or about, as I read to you before, October 15, 2025.
Welcome back to the channel, everyone. Today, we're diving into one of the most unpredictable court hearings we've seen in a while. The People versus Joshua War. From claims of conspiracy and artificial intelligence to a defendant insisting he's more than capable of representing himself, this one has everything. A felony charge, courtroom confusion, and a judge just trying to keep control. But as the tension builds, one question remains. Is Joshua truly competent to stand trial? Or is something deeper going on? Let's get into it.
Location of South Main Street and East William Street in the city of Ann Arbor, Washington County, state of Michigan. That you did fail to stop at the scene of an accident resulting in serious impairment or death. Individual.
The guy was
That is a
perfectly
felony.
fine.
That is a felony, punishable by up to 5 years incarceration and a $5,000 fine plus court costs. You do understand that, sir?
I understand that. Thank you,
All right,
Mr.
count two on that complaint alleges that on that same date and at that same location that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yeah, I understand that.
All right. So that is what you are here for.
Mr. Simpson, I'd like to subpoena the camera footage from the mobile gas station there on North Main Street that I was at, or on South Main Street where I was at, over on South Main Street in Maynard. My car was parked there the whole time. I accidentally hit the guy. They hacked the light using an AI.
So, Mr. Warren, I'm going to suggest to you this.
App, the Tomboys and the Ku Klux Klan, and they had broken my glasses when I wasn't. They took my car for a joyride and broke my glasses while I was at St. Joe's Hospital.
The Klan did?
Huh? Yeah, the Ku Klux Klan. You can subpoena video records, and I subpoena the security guards from St. Joe's Hospital, Trinity Hospital.
That's one of the reasons why you have an attorney. Did you let them know that?
No, I don't have an attorney. I told them I don't want anybody to represent. I said I'm representing myself. Yes.
Is that what you want to do?
Yes, I would like to do that.
Sure.
And I would like to subpoena the camera footage from the gas station.
What the charges are, sir. That if you elect to represent yourself, you'll be held to the same standards as an attorney would regarding the rules of evidence and procedure in the courtroom.
Yes, Your Honor, I understand that.
And not be shown any favoritism.
Yes, and I would like to subpoena my discovery packet, please.
Time you wish.
Now watch this closely. Joshua begins requesting subpoenas left and right. gas station footage, hospital security, even something about AI hacking the lights. This is where reality and perception start to blur. Judges often face a difficult balance, letting a defendant speak freely versus keeping the hearing legally sound. It's uncomfortable to watch. He's fighting for his truth, but without legal training, his approach undermines his credibility. Comment below, is this defiant strength or self-sabotage?
Then to be represented by counsel, you need to make that request to the court.
Okay. I've
To
tried
do
calling the public defender's office and I've tried to tell them I want to represent myself. And I've tried to subpoena my discovery packet and they won't bring it to me. I need to subpoena my discovery packet for all cases available, please. And I would like, yep. And I would like to also subpoena everybody's address in the MDOC that's involved in the Neuralink case through Secretary of State, phone numbers, text messages, and visual voicemail records. And I would like to subpoena the phone recordings, Securus GTL recordings from when I was in the MDOC at ARF level 4 and WCC pictures. And
Sir, I listened to you both through the last hearing and this hearing. So what I'm going to do at this point is I'm not going to relieve the public defenders, but I am concerned, while you have indicated to me that you don't need a forensic evaluation, the court, in listening to you, does believe that you would need a forensic evaluation.
no, I'm perfectly fine, Mr. Simpson.
Sir, for your own
I'm not on Social
protection and
Security.
preservation of your rights.
I'm not on Social Security. I'm over the age of 25. I'm not mentally disabled. I do not need a forensic.
And sir, here's the thing.
I do not
I have
to the forensic center.
I have to, in terms of these proceedings.
This is the turning point. Despite Joshua's insistence that he's fine, the judge orders a forensic evaluation. That's standard procedure when there's reasonable doubt about a defendant's mental state. The court must ensure competency before trial, meaning the person understands what's happening and can assist in their defense. It's a safeguard, not a punishment. Joshua cites his GED as proof of intelligence. But competency isn't about intelligence, it's about comprehension under stress. A vital distinction.
Make sure that you are competent and
Oh, I'm very competent, Cedric Simpson. You can tell. I'm very intelligent. I have a GED. I got a GED in 2013 in 3 months.
All right.
I got a GED from Washington Community College Adult Transitions Program in less than 90 days in 2013. You can subpoena that record. If someone can get a GED in less than 5 months, I'm pretty sure they're competent.
Not really.
And I would like to
Well,
subpoena my GED from the Adult
you
Transitions
can
Program
do
in
that.
2013 at Washington Community College.
Subpoena. I will not relieve the public defender at this point, but I will consider certainly that once the
Thank you. Yeah, that way, if you see I got a GED from WCC in 2013 in 3 months, you know I'm competent. You know what I'm saying? Thank you, Judge.
I am going to order a forensic evaluation. I will set a competency hearing just to make sure. I'm going to set that for January 29th, 2025.
January 29.
a.m. I will sign an order to
Can you give me a
effect
PR bond, please?
I'm sorry.
Can I please, I would like to request a PR bond.
This time you can file a motion, or somebody can file a motion before the court, and I'll consider a written motion, but at this time I'm not going to change the bond in this case.
What is the bond?
Currently, your bond is set at $25,000 cash sure.
And here comes another dramatic moment. Joshua requests a PR bond. That's short for personal recognizance, meaning release without paying bail, just a promise to return. But with a felony charge involving a fatal accident, judges rarely grant those. His bond is $25,000 cash, significant but standard for this type of case. Notice how the judge remains calm, procedural, and unmoved. It's a masterclass in judicial control amid chaos.
Do you have any bail bondsman numbers for me that I could get a hold of, please?
Sorry,
I'd like to subpoena a bail bondsman.
You can check with the individuals at the jail. I'm sure they'll be more than happy to assist you in that regard. All right. So that you understand, I'm leaving the public defender on the case at this point.
No, I don't want a
Get
public
the
defender.
evaluation. I hear you, but I'm telling you what I'm doing. We will get the evaluation. I'd suggest that you be cooperative in that, maybe write it, come back competent, and then we can get this proceeding moving even quicker.
Not gonna come back now. Y'all gonna try it.
Before we go off the record,
Y'all corrupted it. Y'all fucked up, people. Y'all people fucked up. Y'all.
Okay, keep moving. All right, been a pleasure.
Things boil over. Joshua, clearly frustrated, lashes out, a sign of emotional overload. Outbursts like this can deeply affect how judges view credibility and cooperation. Even if a defendant feels wronged, the courtroom demands composure. Remember, judges are evaluating not just evidence, but demeanor. This moment likely sealed the judge's decision to keep the public defender involved. What would you have done here? Stayed silent or spoken your mind?
I'm Benjamin Franklin's son.
Me too.
I just want to,
Because Paris is lovely in this one.
I just want to address one thing, Your Honor, relating to the prosecutor's office's responsibility of providing discovery and as we move forward in this case. The defendant, in attempting to represent himself at the PCC on Thursday last week, stated that he didn't need an attorney, he didn't want an attorney, and that he didn't need the discovery either, that he knew what was going on, and that he wasn't worried about having all the video prior to today's hearing, and we were prepared to proceed today. At the same time, under normal circumstances, we would be in the process of getting all of that video discovery to defense counsel that he referenced wanting today. He mentioned wanting the video at the intersection. My office is in the process of getting that hopefully before the weekend. And I'm looking for permission to provide discovery to Mr. Brown's office on this file moving forward.
In response, Your Honor, as we are still on the case, I would ask that they provide discovery as they normally would.
And then if in January, depending on what happens, then certainly that information can be tendered either if he's going to represent himself, which he may be entitled to do, then the public defender can turn it over to the prosecutors we have in other cases that supply directly to him.
Understood.
All right. Thank you. At least I wasn't called the Illuminati. Well, that's also called a bunch. It was also called a bunch of other things, but that's okay. I'm good with that. I'm confident in me. So, is that your only case, Mr. Brown?
I think it's so long.
Court calls the case of the people.
Court does call the case. What's your names?
Lori Anderson.
All right. We're here today for a decision on this case, but I'm a bit confused about one thing. Ms. Anderson, you filed a new case for non-payment?
Yes, that was just to make sure for,
Make sure of what?
she hasn't paid, September, October, or, rent, so.
Talk about a tonal shift. We move from a felony hearing to a civil landlord-tenant dispute. This shows just how wide a judge's docket can be in one day. The courtroom energy completely resets. But the confusion? It's just beginning. The landlord files 2 overlapping cases for non-payment, and the judge has to unravel the procedural mess. It's less dramatic than Joshua's case, but legally just as tangled. Multiple filings can stall justice and frustrate everyone involved.
I was told to file a 7-day.
Did you put September in escrow? This Friday. And then what about October?
I'm going to get that in as soon as possible as well. I don't have a deal.
So
I thought I was supposed to.
What?
Sorry.
What did you say?
I thought I was supposed to, since she was late for rent for 3 months.
Well, if I render a decision on this case, something's got to be done with that one because this is a non-payment also.
Yeah, it is, sir. I'm sorry.
When is that set for?
November 7th.
That's the 8:30 hearing. What date after that is in what? No, no, this for Tuesday. So here's what I'm going to do. That case, have you been served on that case, ma'am? A new one
So, yes.
to come to court on the 7th?
Yes.
All right. I don't know why that was done, but it's now caused a bit of confusion procedure. Yes.
I thought I was supposed to when it was late. I'm sorry if I made a mistake, but
Well, there's an escrow order that's in this case. And you went through a whole hearing on this case.
Yeah.
And I'm going to render a decision, but that other case is outstanding. So what I'm going to do is I'm going to let that proceed on the 7th. I'm going to adjourn this case to my decision on this case to November 18th to allow that case to catch up because I don't want a stray case out there. You have the option if you want to, I'm still adjourning this one out to that date, but you do have the option that what you can do is you can dismiss that other case because I don't know what you would get out of that case that you wouldn't get in this case.
can I dismiss the
I don't have it in front of me. I don't even know
Well-
where you filed it.
Can I dismiss this case and just go with this one on the 7th? Since it's for non-payment of rent? That's what I prefer to do.
I'm not going to relitigate this whole case.
I just
That's
want,
what you want to do.
no, I just want to do it for non-payment of rent. I can dismiss the,
Well, she's got some counterclaims. You want to just dismiss this case and just go forth on,
Well, we've been here since June, so I just.
oh, I know.
I mean, there's also an outstanding water balance of almost $1,500. So I would just rather cancel this case since I'm the plaintiff and then just go with the 7th.
The water bill she mentioned, she took the water bill out of my name and paid it in full.
It was due on the 6th and they said it would go on my tax bills if I didn't pay
I
it.
don't
So
know
I
why
paid
I'm
it.
talking about a water bill at this point.
Sir,
What do you want to do? Because you've got this thing all over the place.
I'm going to withdraw this case and just go with the 7th for non-payment of rent. She's 3 months behind right now. And the water bills,
How can she be 3 months behind? She's
September, October, and then it'll be November, and then the water bill of $1,500. So it's well over, she owes a total of $15,000, a little over 15, and she has 6,600 in escrow. So it's getting deeper and deeper. The further we delay it, the bigger the hole gets.
I'm not delaying anything. You keep doing stuff.
I want to cancel, I want to sell this one and just go for the 7th since I'm the plaintiff on both. For non-payment of rent, that's all I'm concerned.
No, I know. That's why I don't understand the second case.
Well, that's all I want is to.
I mean, you think I'm sitting up here and don't know anything.
Yeah.
I look stupid, but I'm,
No, you're very smart, sir.
oh, I know that.
I would just rather withdraw this case and just go on with the 7th.
You let me know when you're done talking.
Okay, sir. Thank you, sir.
Are you done?
Yeah, I mean, the other attorney,
You're not. Go ahead.
the other attorney I was working with before suggested that I do that I withdraw this case and just do the 7-day notice. That's what he suggested. He said that would be easier.
You done?
Yes, sir.
Lyman, what would you like to do? So just so that you understand, if she dismisses this case, what I would do is I would pay the escrow over to her, okay, on this case. None of, if you dismissed it, I would be dismissing any of your claims that you have against her. Dismissing any of them with prejudice, you'd be able to raise them in the other one if that's what you choose to do. But that's up to you. And then you'd have to come back on the 7th and we'll see exactly where we are.
I just feel like we should just keep going because we're swiping it.
But
Finish it out.
since I'm the plaintiff, don't I have the right to cancel that one, listening to my counsel?
You should have gotten an attorney before you started. But
No, but that's what he suggested I do. He said,
no, because once she's answered, she has the same right. She can say no.
okay. So if I cancel the one on the 7th, can we just be done with this today? Is that better? I just don't want to keep dragging this on. So if I just kill the one for the 7th and we just,
Ma'am, I can't give you.
well,
the-
that's what I want to do.
as to, well, I don't have that case in front of me. It hasn't even been heard. It was filed.
It was just for non-payment of rent, but since you said it overlaps this one, then let's just cancel that one and just do the non-payment of rent on
Here's
this.
what I'm gonna do. You're gonna stop talking,
Okay.
and then I'm gonna do what I was gonna do at the beginning. And that is, I'm gonna let that other case catch up. They're just gonna be together because you elected to file it. Whether, under what reasoning, I'm not even concerned about that. But I'm not gonna have two cases standing out in this situation. So I'm adjourning this case for its decision to November 18th. When we get to the other case on the 7th, I will try to have that case catch up with this case, and then we can just decide everything, unless somebody wants to file something else in the end.
Thank you.
What time on 18th?
9.
Are we coming on the 7th as well, sir? Okay. Thank you.
So what did we just witness? Two very different sides of courtroom reality. One defendant questioning his own system, and one landlord lost in procedural confusion. In the People versus Joshua War, the judge upheld due process, ordering a forensic evaluation before proceeding, a critical move to protect both rights and justice. And in the civil case, we saw how overlapping filings complicate simple matters. Every courtroom tells a story of law, logic, and human emotion colliding.